Okay, guys, finally, part three of the new normal buyer side of the transaction. We've reviewed the BBRC, we've reviewed the addendums in part two, and part three focuses on the property showing and representation agreement, the PSRA, and the open house visitor non-agency. So the PSRA document is a document that would be utilized. They're sort of referring to it as the BBRC Lite, where you utilize this document if you're going to show a limited number of properties. It is different than the BBRC. You'll notice that instead of 5 pages, it's 3 pages. And so I'll go through the distinctions in the document, but it may be something that you utilize if you're only going to be showing up to 3 properties for you to get started, okay, in order to kind of get in the process. So paragraph 1, parties to the agreement, as in all the other documents. Paragraph 2, talking about show or tour property, the broker agrees to either virtually or in person to show or give a tour of properties that are listed above. So you would list the properties, the addresses of the properties, the 3 that they're going to be looking at. Paragraph 3 talks about the right to represent, putting the buyer on notice that it gives the broker the non-exclusive right to represent the buyer in acquiring the properties listed above. So it puts them on notice that these properties, and they can provide this to another broker if they're working with other brokers or talking to other brokers. They can utilize this document to document that, hey, there has been broker involvement and there is an agreement in place for potentially you as the broker to be compensated on these properties. Paragraph 4 talks about the terms of the representation. So the representation period, 30-day max, as opposed to the 3 months in the buyer broker agreement. 4B1 talks about the amount of compensation. 4B2 explains the amounts paid by seller will be a credit to the amount of compensation the buyer is responsible for. Ultimately, the buyer is responsible for 100% of the compensation, right, guys? But this kind of it softens the blow to them to help them understand that, the request is going to be made that the seller pay the compensation. 4C allows for immediate cancellation. There is no provision to extend that, but they are allowed to immediately cancel it. 4D, other terms. So if there's anything else that they want to add in, sorry, excuse me, I misspoke. Cancellation rights and notice effective immediately, or you can provide a time period for the cancellation period. So typically, non-exclusive is going to be immediately, but you can actually specify a different time period. Paragraph 5, compensation to broker. So the real estate commissions, again, a reminder as they get reminded multiple times that real estate commissions are not fixed, they're negotiable, and they can be negotiated. 5B, broker's right to compensation. 5B1, it is a non-exclusive representation, requires broker involvement in order for the broker to be compensated. And same as in the buyer broker agreement, the broker involvement terms are any of the following. Buyer entered into and was shown the property by the broker. Buyer was shown property virtually by the broker. Buyer made an offer with the broker. Broker performed a market analysis, or the property wasn't introduced, and obviously there was more involvement. There was communication with the listing agent, analysis was done, or communication with the seller if there was no agent involved in it. So just specifying to that buyer what constitutes what would trigger the broker being compensated. Paragraph 5C, timing of compensation. Again, this is similar to the buyer broker agreement. Upon completion of any resulting transaction through escrow, if the buyer defaults, and then the same damages clause that if the buyer recovers damages from the seller, that the broker would be entitled to half of that after costs are deducted. Paragraph 5D, irrevocable authorization of payment through escrows. So the buyer is authorizing through agreement that irrevocably the commission will be paid from escrow. Paragraph 5E, the buyer receives credit for amounts paid from the seller, except in the case broker represents both buyer and seller, and the listing side fee is not part of the credit. So again, same as the buyer broker agreement, but provides for the fact or clarification that any monies paid on the listing side on a double-ended transaction are not credited towards that buyer commission. Paragraph 5F, payments from others that are less than the amount buyer owes broker, again, explains the two things that could occur under that circumstance: conversation between the parties about including the amount owed in the contract, requesting the seller to pay. So you'd use the SPBB to request that the seller pay the amount that the buyer is obligated. And secondly, if the seller doesn't pay as agreed, that the buyer assigns the rights to the broker to pursue the seller for the amount that is owed to the buyer broker. Paragraph 6, cancellation is allowed by either party at any time based on the timeline in 4C. So it's either immediately, which is the default, or some extended time period. Paragraph 6B, broker shall still be entitled compensation on properties with involvement, provided the list of properties is delivered within 5 days of cancellation. Same as the buyer broker. If it's a cancellation, there's a distinction as to when the list of properties with broker involvement needs to be delivered to the buyer. So there is a 5-day period. And then there's a disclaimer to the buyer saying before, during, and after the 5-day period, the buyer is advised to notify any other brokers that there is an agreement in place, and that will be forthcoming within the 5 days if there is a number of broker involved properties. Paragraph 7, buyer agency buyer acknowledgement of receiving the AD, possible dual agency with seller, notifies the buyer that the agent will confirm prior to executing a contract, form PRBS. Paragraph 8, the broker authorizes and the obligation authorizes the broker to diligently represent the buyer in any property listed above. If it is residential 1 to 4, the broker will perform a visual inspection. That's the law. So basically, those are the obligations under this agreement for the broker. And then the buyer obligations that they will act timely, in good faith to communicate and cooperate with the broker. They will also provide personal and financial information if requested to do so. Now, the top of page, this is still on page 2. Actually, it's not the top, it's the bottom. There is a disclosure box, and it's in bold print. And it talks about attending an open house without representation, and then a disclosure to all prospective buyers. And so with regard to the open house without representation, it's telling the buyer you are not required to sign a representation agreement to view the open house. And if you don't want the agent holding the open house to represent you, you should review and sign the CAR form OHNA. So you, as the open house person holding the open house, would have the OHNA available for them to sign in, and it has its own acknowledgments, which we're going to talk about in just a couple minutes. And then all prospective buyers, if you have already signed a broker agreement, you should disclose that to the person holding the open house so that they're aware of that. In fact, you as a buyer, if you're working to buy a home, it becomes very important that you make sure you disclose to anyone that you have these agreements, because you could be causing yourself to be obligated to pay more than you should. If you have already signed a broker agreement and you sign this one, you could be obligating yourself to pay additional commissions. And then last page is acknowledgement and signatures. Again, we talked about the fact that this is for limited use. So if it's for the first 3 properties and it doesn't include all of the language, and it's intended to kind of be an abbreviated version But once you've exhausted that, I would not recommend that you add properties over and above the three. At that point, you need to move into a more formalized agreement where for the fourth property, you would have them sign an actual buyer broker agreement where you would have a specified term. Hopefully you will have been able to demonstrate your value proposition to them in a time, within that time period, and move forward with a standard buyer broker agreement, whether that be exclusive or non-exclusive. I would dare say that most of the agreements that we're going to be dealing with moving forward, to be realistic, are probably going to be non-exclusive. There could be circumstances where you're going to commit the time and resources, or you have that sort of a relationship that you would designate it as a exclusive agreement. Okay, last document that we're going to review for today is the open house visitor non-agency agreement. And so this is basically an open house document that is used as a sign-in. And it's valuable because it has a list of rules for the open house. And the first rule is that, the visitor needs to understand that the agent doesn't represent them, okay? They are there as an accommodation for the seller. They work for the seller. Whether or not they're the listing agent or not, they work for the seller. Paragraph 2, communication at the open house is for the benefit of the seller. Even if the visitors are assisted, if the agent provides them with information, it doesn't mean that they are working for that buyer and that potential customer. Anytime there is going to be a formal relationship, there needs to be a formal agreement. And so you would either use the buyer broker agreement or the property showing and representation agreement. Those are the two that we will utilize to document that. Communications are not confidential. So this is a reminder to the buyer that anything they say is not confidential and may be revealed to the seller, because the party holding the open house is a representative of the seller. Fourth rule, if visitor writes an offer, broker at the time will disclose if they represent the seller exclusively or they represent both the seller and the visitor. If the visitor wants to be represented by the agent holding the open house, they need to sign a buyer broker agreement. They need to sign the BRBC or they need to sign the PSRA, one of those two documents. And then the bottom is for the visitor to sign in and provide their information. In your conversation with them, I would ask them questions like, are you represented? Have you signed any buyer broker agreements? Has anybody ever talked to you about what that's all about? Might be an opportunity for you to educate that client moving forward and help them understand what the new protocol is and how things work. Okay, last part of it, any questions on any of the three sections? You're welcome to post those questions or comments on Mastermind. Very soon, these documents are going to be incorporated into our workflow, and we are going to be required to be utilizing them with the public. So it's important that you familiarize yourself. Hopefully this session and the first two sessions provided you with enough background on these documents. We will be doing additional practical training on these procedures and policies as we move forward. And as we get closer to August 13th and August 17th, you may find with the introduction of the new documents as of this morning, for example, a new listing agreement, you may start seeing listings in the MLS with zero compensation, because there is no place unless you create an addendum in the listing agreement to offer or to identify buyer compensation with the seller. So those changes are in the mist as we currently move forward. So please let me know if there's any questions, comments, and we will take it from there. Thank you for spending the time with me today.